Uh, what's up, everybody? Hokies, how you doing? Risk it. Cozy Gooner, how are y'all doing tonight? I'm gonna set today, but I think it's tonight. I am real obviously live over here on YouTube and live over on Rumble, and I'm waiting to make sure that Rumble is actually working. Right now, it's still just that video looping over and over and over and over. I've got a check mark on Rumble. Yeah, it's going. Okay, we're gonna put something else up. I don't want to see my face over there. What's up, Risk It? I'm sorry. What's up, Breezy? How you doing, man? How's everyone doing tonight? That's pretty cool. We can't post. What does that mean? Okay, I'm going to assume that anything that comes from Rumble, that I am going to see it over in my chat. I think I'm the only one actually over there right now, so I don't really care about it that much. Breezy says he's doing good, bro, playing some Lords of the Fallen and storming in his neck of the woods. That sucks. Hopefully, we've lost power the last 2 nights that I've been live, so hopefully that doesn't happen again. Knock on wood. We have quite the show. We're going to go over a lot of what's going on with the Ninth Circuit Court of Appeals right now. As many of y'all may know already, was it 2 days ago, there was a hearing between Donald Trump and Gavin Newsom in the Ninth Circuit to decide whether or not Donald Trump is going to remain in control of the California National Guard. I've got a lot of stuff pulled up for this, but what I did find, and it's actually the reason why we were a little late, what I did find was the actual hearing. This is the actual hearing of Newsom et al. Versus Trump et al. And obviously, we're not going to listen to the whole thing because that's going to be boring as shit. But one of the things that I find so funny about this, so usually, at least how I think it should be, hearings are obviously held in courtrooms. But this one was held on WebEx, which is I assume it was WebEx. That's what we use here in South Carolina. But it's basically just a Zoom type thing. This might have been Zoom. But fucking the Justice Department is the only one that has any idea of, let's have like a cool background and stuff like that. This dude looks like he's 12. Actually, what this guy kind of looks like? Risk it. Does this guy kind of look like Nagradol? And then Judge Bennett here, he's the head judge for this. Judge Sung. So apparently, I was reading about this case. I think it was Sung and Bennett and Miller. So Bennett and Miller, the two men, are the ones that led most of the questioning. They peppered the Trump attorney, Brett Shumate, with several questions. Oh, Hokies, that was hilarious. Did anyone remember this? It was like right when COVID was happening, and there was an attorney that I guess his son or something had been using his Zoom, and so he gets on for a case, and he just starts. He's just a fucking cat. He's just got a cat filter on. And he's sitting there the whole time going, I swear I'm not a cat, as if anyone would actually think he was a cat. I definitely don't plan on actually watching this. But what I was hoping to get is an idea of where some of the hot questions were in this. You know what I could probably do? There is no transcript. That sucks. Let's see. I'm gonna guess right about here. Yeah, Brett Shoemate's already started to talk. So let's just see what that first question was.
When the appellant is ready to proceed, you may begin.
Thank you, Your Honor. May it please the court, Brett Shoemate on behalf of the federal defendants from the U.S. Department of Justice. If I may, I'd like to reserve 5 minutes for rebuttal.
Okay.
Thank you. The court should immediately stay the district court's extraordinary order because it interferes with the president's commander-in-chief.
So if anyone has forgotten what happened last Thursday, what was it last Thursday? Yeah, let me move my calendar. Yeah, so last Thursday, the district court in the northern, I think the northern district of California said that Donald Trump had gone above his powers as chief executive and commander-in-chief to nationalize the California National Guard, and returned and issued a temporary restraining order that was supposed to start at 12 p.m. on Friday to allow Newsom to retain control of the National Guard. Trump filed, or the Justice Department, I should say, filed a appeal to the Court of Appeals saying the district court is unlawful, yada yada, all this, and asked for a stay of that TRO. The court granted that stay, and this is the hearing to determine whether or not there will actually be a stay on the full TRO, or if that TRO will actually go into effect. There's still a hearing tomorrow in Breyer's Court in California to decide on whether or not that stay actually needs to happen. So the TRO is issued when the judge feels that the plaintiff is likely to win on the merits anyway, and if they don't win, or if they were to wait until they win in a week or 2 weeks or whatever, there would be damage done. They issue a TRO to prevent the damage from being done, and then allow the parties to present their memos, do all that stuff, and then they have the hearing. So that hearing's still going on tomorrow. This hearing was the hearing with the Court of Appeals to decide whether or not the stay actually was warranted. And that decision, as far as I'm aware, still has not come down, which is surprising because it's been 2 days. This was on June 17th. So this was Tuesday. I am sort of surprised. Usually it could take a Court of Appeals months, but this is the sort of case that they would have been going clockwork on.
Powers based on an erroneous interpretation of the applicable statute. It upends the military chain of command. It gives state governors veto power over the president's military orders. It puts Article 3 judges on a collision course with the commander-in-chief, and it endangers lives. Even California concedes that there is ongoing civil unrest in Los Angeles. But this is no ordinary civil unrest. As we've explained in the Santa Cruz declarations, federal personnel continue to face sustained mob violence in Los Angeles, expressly aimed at preventing federal officers from enforcing federal.
Yeah, and we've seen that as late as today. In fact, not only, and this is probably going to hurt Newsom. And if Newsom had been smart, he wouldn't have done this. This big issue happened today. So so ICE agents tried to get to the Dodger Stadium to do enforcement. I don't know if they were going to be going, seat by seat during a baseball game or what, but they were trying to get over there to go execute a raid, I believe. And the LAPD blocked them and escorted them out of the area. That is going to, in my opinion, harm Newsom's defense, because Newsom's sitting there trying to say, we have everything under control. Yes, there was chaos. Yes, it was bad, but we are able to deal with that. The powers that be are still powerful enough to deal with it. It's not, we don't need the National Guard. And if they're unable to, if ICE is unable to do what it needs to do with the aid of the LAPD or state police or local police, I should say, then that's going to go to Trump. That's going to be a check in the box to Trump. And he's going to be able to rely on that, being able to say, hey, of course they need to federalize the National Guard. Of course they need to use the National Guard because their own police aren't aiding the federal agents. So who's going to do it if not the National Guard?
Federal law. Unfortunately, local authorities are either unable or unwilling to protect federal personnel and property from the mob violence ongoing in Los Angeles today. Under these conditions, the president acted well within his discretion in calling up the Guard. Based on
So Hokies asks, how the beep can local PD override the feds when it comes to federal law? This is the thing that's kind of annoying, and I wish I had a better answer. So local police should never be doing that. If there's anyone in a city, town, state, anything like that should be able to do that, it should be the sheriffs. Sheriffs have extreme powers to basically be able to override. They can't go in and say, no, you can't do this, is against this, or you can't do this. They can't do that. They can't basically tell ICE, you can't do this. But sheriffs can refuse to comply. And because they are elected, they can basically refuse to comply and dare ICE to actually do anything about it. It's sort of Wild West when it comes to sheriffs. But local PD, and then of course the big problem is, the LAPD is the second largest police force in the country, second only to the NYPD, for an area of, I think it's 30 or 40 square miles. They have about 15,000 police officers. It's basically an army. And I think the problem is that you've got ICE agents that are 20, 30 strong, trying to basically get around the fact that the local PD are under orders not to comply. Like we saw the other day. What was it? Glenwood County, something like that. Let's see. Glenwood, California. An area in Santa Cruz. Nice. Yeah, Glendale, that's what it was. So Glendale, the city council basically voted to end their contract with ICE, saying that we will no longer comply and we will no longer aid in the detention facility that ICE has here. So this is something that they're having to deal with across the state.
his determination that the violent riots in Los Angeles constitute a rebellion against the authority of the United States that rendered him unable to execute federal laws. Yet the district court improperly second-guessed the president's judgment about the need to call up the Guard.
And remember, one of the arguments that Trump, as the Justice Department, made was that it was outside the purview of that judge, of Judge Breyer, to decide whether or not Donald Trump was acting within his powers as president. They argued that this was not a reviewable thing by a judge, especially not a district judge. And that's another issue. Once again, we have a district judge that's able to make federal policy. Now, this is sort of a extreme case. I do think that this is the sort of thing that I do think, maybe a district judge should be able to decide. But when you have, I did a video 3 weeks ago where we talked, or actually it might have been the first fucking video I did. It's in my description for that video. Let me pull it up real quick. Trump had issued about 150 executive orders in his first 3 days, and in those 150 orders, I think it was 123 TROs have been placed on each order. Let's see. Yeah, how federal judges have halted 123 of President Trump's 142 executive orders in his first 100 days. So this is an issue that the left is using the court. They're using the court as a weapon. And the problem is whether you have activist judges or whether you have judges that are just scared to make the decision. So I'll give you an example. Birthright citizenship. Birthright citizenship is this concept that has come out of different court cases, stretching all the way back to, I believe, the 20s. Basically saying that if you're born in this country, you are a citizen of this country, and which has given rise to Chinese people coming over here to give birth and having children with dual citizenship, immigrants from Mexico and other South American countries coming up just to give birth, to have anchor babies, all that stuff. So because it's given rise to this, Donald Trump sees an issue and says, okay, it's time to end this practice of birthright citizenship. You want to be a citizen of this country? Come here legally. Do the correct way. Don't sneak over the border, have a kid, and then go, oh, you can't separate me from my child. So what the issue is, you end up having a judge that hears this case and goes, this is too big for me to decide. I'm not going to be the one to decide this. So he or she, puts a TRO or an injunction on the order, knowing that it's going to make its way up to the Supreme Court, where the arbiters of the Constitution will decide whether or not, whether or not birthright citizenship is legal, and two, whether or not Donald Trump can actually put into birthright citizenship as a practice in an executive order, or if it has to be a law. So that's going to be interesting.
In order to protect federal property and personnel from mob violence.
Again, any questions, ask them, and I'll see if I can answer them.
In Los Angeles.
Mr. Schuman. So I want to start by drilling down on one aspect.
See, I think he got a minute. Let's see. So this was at 2:32.
Civil unrest in Los Angeles, part of misinterpreted because the court should immediately stay the district court extraordinary order.
Is that better?
Because it interferes with the president's command.
Yeah, so he got a minute and 32 seconds in before he was interrupted by a judge. That's actually a little slow. I'm surprised they waited so long.
Of review, and I'm going to be discussing subsection 3 only of section 12406.
Okay, let me look that up. Subsection 3 of section.
And 3 only of section 12406.
102.406. That wasn't it. Hang on.
Subsection 3 only of section 124.
124.
06.
06. Okay, what does that say? That's when the National Guard is called into service. Section 2 is what he cited earlier, where it says, whenever there's a rebellion or danger of a rebellion against the authority of the government of the United States. So this is what the courts are going to drill down on, because this is what kind of keeps getting repeated by the administration. So it's that they've decided that this is the reason that he has federalized the California National Guard. So they're going to be drilling down on that section.
And you just said the president acted well within his discretion. And again, just as to Section 3, is it the United States' position that the court has no role at all in reviewing what the president has done in calling forth the militia under subsection 3? Or is it the United States' view that the court has a limited role and needs to afford the president very substantial deference?
Oh, this is going to be a good answer.
Or is it something else in deciding whether the requirements of subsection 3, inability with the regular forces to execute the laws, is met?
Thank you, Your Honor. Our view is that this statute commits the decision whether to call up the forces to the president's unreviewable discretion. So no, there's no rule.
Oh, okay. So they are arguing that the court has no role in reviewing this decision. Judges aren't going to like that.
Court to play in reviewing that decision. And I think it's important to note that the statute here is very similar to the statute at issue in the Martin case that we've cited, the Act of 1795, which had a similar structure. It had the whenever clause followed by a delegation to the president to call up the militia. And in that case, the Supreme Court in 1830 said, that's a decision that's committed to the president's discretion. It's not for a court to review that.
So the most annoying thing about this sort of issue is it's not something that happens a lot. So any case where you're going to find evidence both pro and against your side, it's going to be, maybe 1930, 1845, 1798. Like, it's going to be really old. So I would be interested to find out, and I hope we do, on whether or not these judges are annoyed by the fact that any precedent cited is 100+ years old.
That decision. The plaintiffs try to make out that decision as an outlier, but of course, there have been many cases since then involving unreviewable decisions committed to the executive. The last we cited is the Dalton case.
So is it your view that if the president,
Judge Miller doesn't seem to be enjoying Bennett overruling him all the time,
or a future president, simply invokes the statute, gives no reasons for doing it, provides no support for doing it, and there is nothing which would appear?
Hoagie says, can the local PD be arrested or charged for helping people escape the feds? They help people that at least broke immigration laws and possibly other laws. Yes, they absolutely can. That is... So it depends. Honestly, it depends on how they do it. So that's either a violation of 18 U.S. Code Section 1505, 1509, or 1511. So 1509 deals with obstruction of court orders. If there is an active immigration warrant out for, let's say it's Javier. So let's say I show up with a court order saying, I'm here to arrest Javier. He's in violation of yada, 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 and he's going to jail. Then if the local PD or if anyone obstructs me of what I'm trying to do, exercising that warrant, that's obstruction of a court order. He's out. He's going to jail. If ICE shows up and tries to arrest people and the local PD prevents them from arresting anyone, that's obstruction of proceedings before departments, agencies, and committees. Wait, is it? Hang on, let me make sure. No, that's so this would be 1511, obstruction of state or local law enforcement. So you cannot just go and prevent people from, you can't prevent ICE agents, you can't prevent the FBI, you can't prevent federal law enforcement from exercising their job as federal law enforcement to arrest people. When you do that, it's called obstruction of justice. It's called impeding a law enforcement officer. And states have more laws for those things because they need them. Usually the gold badge that says FBI is enough to get you anywhere you need to. Only now are we seeing these idiots trying to impede federal law enforcement. King says he's illegal, or Schick says he's illegal and he needs my help. Well, I am not an immigration attorney. I will never be an immigration attorney. In fact, there is a law firm in South Carolina. I don't know if it's just in Charleston or it's just in Columbia or if it's a statewide law firm that I have seen an ad for an immigration attorney from that law firm for the last 5 years. So either they are constantly growing or no one wants that fucking job. And I am not monetized yet, Schick. No. So the King's Court still needs. We got number 180 came in today. Whoever you are, I love you, man. So we still need 320 subscribers and watch hours. We need somewhere in the neighborhood of 2,500. But we're getting there. We're getting there. Look, this is growing, and this is going a lot better than King's Advisors did. Oh, I just exited the video. I was supposed to be professional, wasn't I? Okay, let's pull that up. Give me 1 second, guys. We're not going to go through the whole thing. Obviously, that would be extremely boring. But I kind of what I want to do is I kind of want to get a feel of what those judges are thinking. It was pretty clear in Breyer's case that Breyer was not a fan of Trump's decision, but appeals court judges are supposed to be a little more nuanced, a little more easy at kind of figuring out how to ask questions without tipping their hand. One thing we do know is that it is Miller and Bennett that lead the questioning for most of it. I'm curious what Sung's questions are going to be. I kind of want to see if, and what's interesting. So Samuel Harbert, something like that. He's the attorney for Gavin Newsom, basically. And so because he's sitting down, we can kind of see when he actually gets up to start talking. So they question Shoemate for about 26 minutes. They finally get, and then he disappears. Shoemate disappears. All right. I'm gonna fast forward. We're gonna go look at what Harbert says. So Bennett really seems to what does he seem to do? Drill down on Section 12406, which is the federalizing of National Guard. He really seems to drill down on both whether or not the judges can review a president's decision to federalize the National Guard and what the definition of rebellion is. Clyde, I would love to, but we're not, I'm not going to call people up and say, hey, get in here. I'm not going to go turn on my TVs and, select, You know, I want all this to be natural. I want if you want to watch. If you don't, I totally get it. So I'm curious what Harbert is going to say, and then I think we're definitely going to listen to the full. It looks like it's about 3 minutes of rebuttal from Shoemate.
California.
Good afternoon.
So I'll tell you right now what he's doing. What Harbut has just done is he's gotten out. Like, he's still listening, but he's gotten out so that all of his team can come around and start addressing all the questions that the judges. I guarantee you there's a team of attorneys, probably 15 attorneys in that room behind that camera, just waiting. They're writing down, going, okay, and each one has probably been assigned a topic so that when that topic comes up in the questions, he's ready to go with an answer to kick back in this rebuttal that he's got at the end.
Your Honors, and may it please the court, Samuel Harbert on behalf of the governor and state of California. Defendant's motion for a stay pending appeal should be denied. The framers of our Constitution.
Hang on. One thing I want to look up. Okay. Whoops. Samuel Harbert. He is a supervising deputy solicitor general for the state of California. Okay, he is, if I can do my math right, he's 37, just about. He might be a little bit older, but my guess is he's probably about 37. First off, he looks more like he's 28. Like, I'll be honest, I looked him up because I thought he was about 30. And I'm 30. I was going to say, this dude is arguing in front of the Court of Appeals for the fucking state. I mean, I don't care what side of the aisle he's on. That is just congratulations. He'll remember this for the rest of his life.
Gave Congress the authority to enact statutes governing when the president may call forth a state's National Guard into federal service. The only statute invoked here, 10 U.S.C. section 12406, requires that one of 3 factual predicates exist before that authority may be exercised, and requires that the federalization order be issued, quote, through the governor.
Let's see. Okay, it does say that, yep.
But on June 7th, for the first time in our nation's history, defendants federalized thousands of members of the state National Guard in circumstances where none of those factual predicates exist, and they circumvented the governor, who did not.
So here's my issue with this, and California has kind of argued this a little quietly several times in the last week. This is a lie. This is not true. This is not the first time that the president has bypassed the governor. It's also not the first time that there has been, quote unquote, not a rebellion going on. Who was it? Was it JFK or was it Lyndon B. Johnson? Arkansas segregation. Let's see. 1957. So that's going to be Lyndon B. Johnson, I think. 1957 president. No, that's actually Dwight D. Eisenhower. Yeah. Okay. So it's Dwight D. Eisenhower, actually. Dwight. I'm assuming I'm right about this. It could be it could be the Alabama one, but I think it's the Arkansas one, where Dwight D. Eisenhower bypassed the Arkansas governor, activated the National Guard simply because they wouldn't let a black kid in a school. That's not a rebellion. That's not a invasion. So this is a lie from California. California is trying to pretend that what happened in Arkansas or Alabama, whichever one it was, didn't happen. And that's not true. It happened.
Not received the order and who certainly did not issue it. For those reasons, the district court rightly held that the state is likely to prevail in showing that these actions exceeded the proper bounds of executive authority. In each of the equitable factors, counsels strongly against a stay pending appeal, which would allow defendants to prolong this unprecedented, unlawful executive action. To be sure, Los Angeles has seen certain episodes of unrest and even violence in recent days, including violence directed at state and local law enforcement officials. The state has strongly condemned these acts, and it has responded forcefully to them. And I would appreciate that.
I finally see Judge Song ask a question right here.
Illustrates that Congress knew how to allow an order to be issued through a commanding officer instead of a chief executive, and it didn't do that with respect to the governors of the 50 sovereign states.
Council, I want to go back to the what you're arguing in terms of the conditions necessary for the president to exercise its calling forth power.
This is going to be interesting.
As delegated by the statute. I hear you arguing that the exigency required under subsection 3, essentially the inability to execute the laws with the regular forces, wasn't met. I don't hear you arguing that the president cannot rely on that subsection based on anything it said in the executive order, or that it wasn't properly invoked or relied on. I hear you arguing that we can and should consider the evidence put forth before the district court, not that we would be limited to what's in the executive order. So are you conceding those points?
If I understand the question, I certainly acknowledge that, yes, the district court should have been looking at the evidence put forward by the federal government to try to satisfy the factual predicates required under section 12406. And as the district court rightly concluded, the federal government had failed to provide argument or evidence that would even really make a serious attempt at satisfying that predicate, because it didn't even suggest that it contemplated more modest measures than calling in the National Guard.
I'll try to clarify my question.
Here we go.
You are not arguing that we would be limited only to what was stated in the executive order to determine whether the factual basis is there. Is that correct?
I see. That's correct.
And you're not arguing.
Okay, so let me see if I have this correct. She is wanting him to confirm that he is not saying you can only look at the executive order. You cannot look at other stuff. You cannot look at the news. You cannot look at the videos. I think this is a mistake on his part, because if I'm understanding this correctly, he is saying that, yes, you have, as judges, you're not only are you able to decide if the issues existed based off of what Donald Trump said in his order, but you're also able to look at what was going on in California on the 7th of June when Donald Trump issued the order. So the 7th of June is a really bad day to allow them to go look at what's going on.
That the executive order failed to rely on subsection 3 or invoke subsection 3. Is that correct?
That's not an argument that we've made, at least at this preliminary stage of the litigation. That's right. Although I do think it's notable that the federal government has principally relied in its papers and in the executive order on prong 2, which I do think suggests that they understood they didn't make a serious effort to show evidence or argument as to prong 3.
Well, so again, this is prong 3 is the president is unable with the regular forces to execute the laws of the United States. Well, the regular forces for the president are ICE agents, FBI agents, DEA, DIA, all that kind of stuff. The normal federal law enforcement agents you think of. The normal forces for the governor would have been the LAPD, state troopers, the LA County sheriffs, stuff like that. The problem is we saw the videos. We know Donald Trump was unable to get federal law enforcement out of buildings because they were surrounded by violent protesters. We've seen the videos. There is absolutely nothing. There's no need to waste the time arguing this. You can literally just say CA and attach every single video, and there's your proof that prong 3 is met. Now, they still should have argued it. I have not looked at what the memos say, the memorandums that the administration provided. I need to. I should have, but they're very long, and I wanted to play video games instead. I'm sure you can understand. But yeah, no. So this is what I think is interesting about this. So we've got 3 judges here. I've got a list of where they're from. Let's see. I know I saw this. Here we go. Bennett and Miller. So the 2 men were appointed by Donald Trump. Sung was appointed by President Biden. I could have sworn that I saw where each of these judges sit currently. Well, one of them is in Portland, one of them is in Honolulu, and one of them is in California, I believe. So, Pierce, it's funny you say that. Should the Court of Appeals rule? Well, after the Court of Appeals rules, which I'm surprised they haven't ruled already. But once the Court of Appeals rules, the loser can appeal to a full panel of judges out of the Court of Appeals. So that would be there are 29 judges that would make up the 11-judge panel that would hear this case. After that, it would go to the Supreme Court. So it's going to be interesting.
Okay.
Your Honors, with permission of the court, I know that I've gone past my time. I would like to very briefly address irreparable harm.
That's fine, counsel. Please do so.
Thank you, Your Honor. We would ask the court to reject the government's motion for a stay pending appeal, because every day that the stay remains in effect, it causes these 2 principal forms of irreparable harm that I'd like to highlight. One is the concrete harm to important state functions that are not happening because of the diversion of.
And which ones are those? California has like 14,000 members of their National Guard. I think it's even more. And you're saying 2,000, or I guess technically now 4,000 members prevent the National Guard from doing its job?
1/3 of California's National Guard troops that are available to the president's unlawful mission on the streets of Los Angeles. That's causing harm in terms of not having troops on the ground ready to respond to emergencies, especially wildfires, which is especially problematic as we enter the peak of wildfire season, which experts believe is likely to be especially harmful and severe.
So something that I think could happen here is I would not be surprised to see the judges decide, whether it's these judges, whether it's Breyer at the end of it, or whether it's the full panel or something. I wouldn't be surprised to see the judges basically say, Okay, Donald Trump's original order stands. It's fine. He can do that. But calling up the additional 2,000 seems to us to be unlawful or unjustified, most likely. Well, Hokie, so this is the thing. California, one of the unique things about California's National Guard is that it does have firefighting units. So there are 14, I believe, might be 12, but there are 12 units in the California National Guard. I don't know what the size of the unit is. I don't know if they're battalions, brigades, regiments, etc. That are firefighting units. And 2 or 4 of those units are busy in LA right now. So there's an argument for that. I hate to say it, but I think Hesketh messed that up. Whose ever job it was to say this one, not those ones, this one, they messed up. They should not have activated firefighting units because they should have remained ready to go, especially with, assuming he's correct, with the start of wildfire season coming up. Those units should have been on standby already.
For this year,
let's see.
Can say it's important to bear in mind the sheer scope of the president's order here. We've been focused today on the conditions in Los Angeles, but the order is not limited. The president's order is not limited to Los Angeles or even California.
So this is a great point. I was making this point the other day. Gavin Newsom messed up here. Gavin Newsom should not have filed this lawsuit. He should have said, you know what, Trump, I completely disagree with you. But to argue this case could create irreparable harm to the way the system works. So what I'm going to do is I'm going to make a deal with you. I will activate 1,500 members of the National Guard, and I will place them at your disposal in the federal districts of LA. But I do not want them doing A, B, or C. A could be, going door to door arresting illegals. B could be riding along with the LAPD. C could be whatever. And I think Trump might have taken that. But the problem is Gavin Newsom has basically put the entire system of federal versus National Guard on trial. And if the court sides with Trump, then that entire system is gone. So what happens in 15 years when we actually do have a tyrant? When there actually, or 20 years, when there actually is some sort of a guy that has this like fetish with wanting to be, a General Dwight D. Eisenhower like guy and decides I'm going to federalize them all. What do we do? So I think this is a dangerous thing to fuck with. I would not have done this lawsuit if I were him.
There's no limit.
I want to see what
you have time.
Here we go.
All right. Thank you. Mr. Shumate, you have time left.
Thank you, Your Honor. If I may, I'd like.
So this is 3 minutes and 3 minutes and 16 seconds. I'm very curious what he's going to argue against.
To make 3 quick points in rebuttal, and I want to start first with the Martin case, which there's some discussion of that case. The point I want to make is that decision is both controlling and it remains good law. It's controlling.
So what?
Because the statute in that case is very similarly structured.
So a controlling statute is a statute that is still, or a controlling case is a statute that is still, is a case that is still good law. It's not a case that the Supreme Court has struck a little bit of the decision down on. It's not a case that has been completely reversed. For instance, if you were to cite Roe v. Wade on something having to do with privacy, you would probably have some bad law there because Roe v. Wade has been overturned. So if I was going to bring up a privacy case, I would cite something more like Terry v. Ohio, which was a Supreme Court case that basically decided how how police are able to stop and arrest people, or do what kind of searches can go on incident to arrest, things like that. Yes, Hokies, the Terry stop. Jeanne, I'm sorry, but that's just the way we talk.
To the statute at issue here. The Act of 1795, again, started with a wherever clause, and it had one condition, invasion. And if that condition was met, the president could call forth the militia. Here, the statute also starts with a whenever clause. It also includes the invasion prong, but it also has two additional elements. And it concludes with a delegation to the president that he may call forth the guard if, in his judgment, it's necessary. So I think in deciding a reviewability question, you look at the language of the statute, not factual distinctions on the ground. Yes, in that case, it was an invasion, it was a foreign policy matter, but this statute also, that's before you here, Title 10, also invokes foreign affairs powers and the president's domestic powers as well. And it's also remains good law, right? We cited the Dalton case, which was a 1990s decision that invoked the same principle, where a statute is drawn in a way that delegates broad discretion to the president. Courts don't just defer to the president's judgment. Courts don't review the president's judgment. And that's what we have here. And in that case, it was a domestic matter, not a foreign policy matter.
So it does look like they are going 100% into the, y'all do not have the right to overturn the president's judgment in this case. Here are 3 examples, and I'm sure they have even more examples in their memorandums. But here are a bunch of examples where here's the breakdown of the law. It's a whenever law that defers power to the president, and the judges and justices do not overturn it because they don't have the right to look over the judges or the president's power when it comes to foreign affairs.
Martin would not be just limited to foreign policy matters. The second point I wanted to make was the easiest path to a decision here is on the third problem. The president made a determination that he is unable, based on with the regular forces, to execute the laws of the United States. The record certainly bears that out, not only in his proclamation, but also in the declarations made clear, and the plaintiffs have conceded there is civil unrest in Los Angeles, but not just ordinary civil unrest. Civil unrest is targeting federal law enforcement officials and designed and aimed to prevent them from carrying out their duties. The court,
and that's going to be the biggest part of all this, that the duties of federal law enforcement are being impeded. And until the LAPD steps up, until the California law enforcement steps up and actually aids the ICE and FBI agents in furtherance of their duties, Trump's going to have a valid argument for needing National Guard there. I brought it up earlier. The LAPD prevented ICE from doing a raid at the Dodger Stadium today. Until that shit stops, it's not going anywhere. Donald Trump's going to have a right to do this. Yes, Zoom court. I wonder what kind of undies and flip-flops they have on from the waist down. Reminds me of COVID. Well, I'm going to argue probably none, or probably a lot, because it does look like they're all in offices and stuff like that, except for wherever Bennett is. Bennett's in like his woodworking shop. What background is that?
Should at least defer to the president's judgment under prong 3. And then finally, on the through language, I think the plaintiffs have an extraordinarily dangerous interpretation of that statute. Under their reading of the statute, Governor Newsom could pocket veto the president's orders, not convey them, and wait for somebody to come down to Sacramento and consult with him before he issues that order. That is not what the statute says. The statute says through the governor, doesn't say by the governor. We've cited other statutes that are similar that contain the consultation language. This statute does not contain that language. In sum, Your Honors, we would ask you to grant our motion for a stay pending appeal. If you deny our stay pending appeal, we would ask the court to give us an opportunity to seek emergency relief from the Supreme Court. Thank you.
Oh, so hang on. They don't even want to go to the full panel. They want to go straight to the Supreme Court if they deny the appeal. That Man, this would be, this is going to be, I really hope this gets to the Supreme Court. This is going to be, can you imagine listening? Okay, I would tell y'all right now, if this is televised, I'm taking the day off work and we're just going to sit here and we're going to watch it. Because can you imagine listening to Kidget Brown or whatever her name is spend 4 hours asking one question? Oh my God, I hope that happens. Okay, let's see if we've got a decision yet. Nothing in the news. Anything on Twitter? Ninth Circuit. It's last year. Whoa, is this true? Okay, I have seen this pop up twice now on Twitter. Let me look this up. Ninth Circuit Court of Appeals voter ID. Arizona. This looks like it's from February. So I'm seeing stuff saying that the Ninth Circuit Court of Appeals ruled that Arizona voters must provide proof of citizenship to vote. But every single tweet is basically the same thing. Where is this? Ninth Circuit. I wish there was like a Twitter account for it. Circuit Court of Appeals that would announce their rulings. I'll figure it out later. Yeah, Mark Reality. Caroline Levitt. That is the name of his press secretary, right? Yeah, Caroline Levitt. She's already said 2 or 3 different times that this is a war. This lawfare, this is a new war that Donald Trump is fighting. And he knows, and the administration knows, they're going to take L's in district courts, but they're going to win when they get to the Supreme Court. Because not only do they know they're going to win because the unspoken, we appointed 3 of those justices, even though Amy Coney Barrett seems to be a kind of a mistake, she's still, and again, Corn Boy, yes, I agree. ACB has been a very big letdown, but she still sided with the conservative majority in the transgender case in Tennessee yesterday. A 6-3 decision. There's also a 9-0 decision last week. So she's been off and on. Something tells me that it has to do maybe during a certain time period monthly when decisions are made. Who knows? Oh God, wouldn't that be fucking hilarious if you could map that? What? I can't just ID myself like the guy at the known press conference? Yeah, you can't just run up and go, I'm Senator Alex Padilla. I'm Senator Alex Padilla. Just trust me on that. Let's see. Yeah, I mean, it very well could have a lot to do with her church affiliation. One thing I do need to do is I want to actually find out definitively if she is a mistake. So we know that there have been several times that we've kind of thought, oh, we might have this in the bag because of 5 justices. Because you can't really count on Roberts, because Roberts is kind of a flip vote. Bush kind of fucked that up. Roberts is not terrible. And Roberts does seem to be a pretty good justice, especially a pretty good chief justice. But I think Bush was thinking that he was appointing another Rehnquist, and he definitely did not. Do the courts have the power to make that ruling? Article 2 says that state legislature make the voting rules. However, the motor voter law is federal. Here we go, market reality. So, in 1965, when the Civil Rights Act was passed, in 18. Was it? Hang on. Section 4 of 15th Amendment. $14th Amendment, maybe. This might be it. Okay, I think it was the 13th Amendment. Okay, maybe it wasn't. I'm going to figure this out. All right. I'll find out what it was. It's either Voting Rights Act, or the Civil Rights Act of 64, or it's the 13th or 15th Amendment. I can't remember which one. But the final section of it said that if any of these states, and it basically listed the Confederate states, makes a law about voting, that law has to either be approved by a full panel in the state that they sit in, so, or the circuit that state sits in, or it has to be approved by a 3-judge panel in DC. South Carolina and several other states in 2015, I think, sued to have that section struck out. They said it was a violation of Article 2, which says that state legislatures are completely in charge of voting. That's why federal laws that have to do with voting are not about voting. They are about inclusion of voting. That's why the federal law that says you can't put taxes on voting, you can't keep people from being able to vote as long as they're 18 and stable. That's why those aren't necessarily about voting. They're about being discriminatory. So this is interesting because, well, it is a state law, Mark. It's an Arizona state law that says they have to do. I haven't seen the law, but it says they have to do several things, and then in order to vote, you have to submit ID. And in February, the district court in Arizona put a restriction on it. They stopped it, or put a stay on it, I should say. And the appeals court apparently today ruled that the law was lawful. Again, I can't find that actually happening. I only see it on like a bunch of Twitter account, so who knows? Until SCOTUS decides, little district judges will always impede. Oh, I want some ice cream. I don't need ice cream, though. Oh, what's this? Okay, we're going to pull a little bit of a J, and we're going to look at this. Something tells me that there's going to be some language in this, so apologies.
All right, motherfuckers, I got one for you. So I just dropped my kid off at school, okay? And I go.
That was really quick.
Go in his classroom. Now, you gotta hear this. You can't make this shit up. So I go in his classroom, and he's got a little substitute teacher in there, and she's got her little mug sitting on her desk. And what does it say? 47. I'm like, oh, I wonder what that stands for. Light bulb goes off when I see her little bag there that says, Make America Great Again. Now, here's where I have a problem with this. The Republicans don't want teachers teaching about LGBTQ or anything racist or anything of that nature in schools or different cultures or anything that could be kind of edgy. But it's okay for a teacher to walk in with a damn big mug there that says 47 in a bag. It says Make America Great Again. Make it make sense. How hypocritical is that of the Republican Party, and how hypocritical is it for people that are MAGA supporters? I just don't understand the relevance behind it. If you can't walk the line on that.
So, a couple things. One, I doubt it, because I've met 2 or 3 conservative teachers, at least that I know are conservative, and none of them would feel safe to actually bring in conservative stuff because they would be judged by the rest of their colleagues. The other is, I don't think any teacher needs to be promoting any sort of politics. Your job is to teach my kid how to read and do math. That's it. Leave everything else at home. I'm starting, you know where I'm at? I'll tell you where I'm at now. You know how kids today now have to go to school with clear backpacks? They go through metal detectors, and that's what we need for teachers now. You have to bring a clear backpack. We have to look at every single item you put in your thing. And I'm going to make a fucking list. You can put an American flag, you can put a state flag, you can put a map of the world, you can put charts and graphs. If you're a science teacher, you can put the table of elements, the periodic table of elements. You put a chart about the water cycle. That's what you can do. You put a single political, conspiratorial, even religious to this point item in your thing, I want you fucking fired. My job, your job as your child's parent is to teach them about religion and to teach them how to be a better person. That's it. Well, obviously more, but that is not your fucking teacher's job. So leave that to me. I will teach my kid about God and what God to pray to and who to vote for. You will teach him how to fucking read. That's it. Even then, I'm still going to tell you whether or not if you're doing it wrong. How was that, guys? What is this? Ooh. That's funny. Okay. What was I going to look up? Ninth Circuit. I want to see if dude. Make my day. Let's see. Latest. I'm not seeing any. Yeah, I am not seeing any actual decisions from the court yet. That's unfortunate. It's been several days. Yeah, Hokies, she sent me something to set up, and I just haven't yet. Dead air, Jay. Man, Breezy, why are you a transformer? She told me to do that, and I haven't, and I should, because I mean, obviously. Okay, let's look at. Ooh. Okay. Oh, right. Shit. I need just about 2,500 to be monetized at that first level to super chats, membership, stuff like that. And then obviously to get to the full level, I still need 820 subs and 35. Yeah, about 3,500 watch hours. So we still got a ways to go, but I mean, this is growing faster than King's Advisors did. So fingers crossed. Guess who's back in the news? Our bestie, fucking Al Green. So, who remembers? Yes, Mark Reality. Many hours of watch hours. Well, so I think part of the reason is because if everyone was able to get monetized at, let's say you get monetized at 100 subs and 1,000 watch hours. Well, what are the odds that Google's going to make a decent amount off of those 100 subs? Let's say those 100 subs throw in a couple of bucks here and there. Google's not going to make that much money off of it. And then are they going to make, because they have to pay, no, because it's $10.99. No, you're right. Because they don't pay any of the taxes. They don't pay any payroll tax or any of that shit. Yes, so this is my favorite thing. Congressman Al Green thinks that it was the impeachment warriors that got Abrego Garcia returned back to America. That it was their arguments and their rallying and all their shit that forced the Trump administration to get El Salvador to release Abrego Garcia. But it wasn't. It just wasn't. You want to know why he was released? And we all already know because it's already made the news. He was released, or he was extradited back to America so that he could be indicted and tried for human smuggling. That's why he's here. And whether or not he is convicted or found innocent, he's going to be returned to El Salvador. Nothing's going to happen to him. They are still championing the wife beater. Mark Reality. Would that be this right here? Is that the website you're talking about? Because hang on. Let's see it change. Hang on. Wait for it. Oh God, this is gonna take forever, isn't it? I just want to see the infinite drop. Oh, that's dumb. Okay. Back to Al Green. Yeah, I wanted to see the inception. Somehow in my mind, it was going to be a bunch of like, but it definitely wasn't. That was pretty pathetic. Yes, if you want to follow me on Rumble, I don't know how to do this. Is it my channels? Yeah, I think it's this. I think that's it. I don't really. Rumble is not the like best designed website. All right, let's go back to this. So Al Green, remember a couple months ago, Al Green basically said that he was filing articles of impeachment on Donald Trump, and then pulled them. Said, maybe not. So he got up there a couple of weeks ago and was like, I'm doing it again. And now he's basically claiming that these off again, on again impeachment things are his way of getting people to see the issues and getting his way against Donald Trump. Is he retarded? Like, he's dumb, right? I mean, we know he's dumb, but what the hell? He did actually have. Also, I love how there are coronavirus resources up here. 5 years after the fact. What does it go to? It just goes to the CDC website. That's hilarious. Let's see. I know he's got. What the fuck is Slavery Remembrance Day? One-page info sheet. What is this? The resolution passed on July 27th supports the establishment of a Slavery Remembrance Day on August 20th. Unlike 9/11, Pearl Harbor, and the Holocaust, there is no Remembrance Day for slavery. August 20th was chosen to commemorate the day the first slave ship, the White Lion, arrived in English-speaking American colonies at Point Comfort, Virginia. Near was now Norfolk. Unlike Juneteenth, Slavery Remembrance Day is intended to be a day to commemorate the victims of slavery instead of celebrating its end. Yeah, I don't give a shit. I wanted to get his actual, because he's got an actual like thing that shows what his articles of impeachment are. Nope, that's still the same website. Same website. So it was House Resolution 415. So let's pull that up. House Resolution 415. Share this tab instead. They are incredibly obsessed with slavery. So this thing is kind of annoying. I was reading something like 2 or 3 weeks ago. I forget what it was, but it was talking about how racism and shit like that had basically gone away in, let's call it, the 80s and 90s. That it was pretty much like, oh, you're okay, you're a person, how are you going to treat me? I'll treat you that way. And then the Democratic Party started like pushing these ideas of not only identities, which obviously led to identity politics, but this idea of victimhood. And suddenly everyone is incredibly racist, whether you're white, black, purple, green, polka dot. It's terrible. Okay. Resolved that Donald John Trump, President of the United States, is unfit to be president, unfit to represent the American values of decency and morality, respectability and civility, honesty and propriety. Hang on, my fan just. There we go. So I have a fan on my desk. There, that's bad. So Article 1, devolving democracy within the United States into authoritarianism with himself as an authoritarian president. Oh, he's taking Merriam-Webster's definition. Cool. Exactly, Clyde. The Constitution provides that the House of Representatives shall have the sole power of impeachment, and they do, and that the president shall be removed from office. Yeah, okay. We're going to quote a bunch of shit. In his conduct while president of the United States and in violation of his constitutional oath, faithfully to execute the office of the president of the United States and to the best of his ability, preserve, protect. Okay, we're quoting a whole bunch of stuff here. High crimes and misdemeanors causing the devolution of democracy within the United States of America. So he's quoting a interview that Trump gave with Sean Hannity on Fox News, saying that he was basically saying, I'm going to be a dictator on the first day so that we can close the border and we can drill. But after that, I won't be a dictator. Unfortunately, President Trump's authoritarianism did not end on day one, but instead continued through condoning the undermining of the judicial independence of the federal judiciary, destroying the separation of powers, violating the Due Process Clause in the Fifth Amendment of the United States, denigrating federal judges, condoning the flouting of orders of the United States federal courts, including orders of the United States Supreme Court. So again, I don't know how many times I have to say this. The president does not have to does not have to be nice. He doesn't have to sit there and go, what's a nice way of saying these judges are being total asshats? He doesn't have to do that. He can say whatever the hell he wants. The First Amendment applies to him too. On Wednesday, April 16th, 2025, James E. Bossberg, Chief Judge, United States District Court of the District of Columbia, found that probable cause existed to hold the Trump administration defendants in contempt for a willful disregard of his order. The relevant part of the memorandum opinion stated as follows. Okay, when are we going to get to the high crimes and misdemeanors? This radical left lunatic of a judge, a troublemaker, an agitator who was sadly appointed by Barack Hussein Obama, was not elected president. This judge, like many of the crooked judges I am forced to appear before, should be impeached. Okay, he's not allowed to say that. So again, yeah, Hokies, this is such a good point. There were so many members of the House of Representatives who decided that Clinton needed to be impeached because he had broken the law and he had lied to Congress. But the Senate decided that there was not a reason to remove him from office. They punished him without actually punishing him. So that is another reason why the House impeaches and the Senate convicts, because there was an understanding back in the day, and obviously that seems to have been lost today, that he needed to the president needed to have a punishment, needed to have the ability to be punished without being removed from office, and being impeached is a punishment. Exactly. His misdemeanor is not being a Democrat. Let's see. So, I mean, a lot of this, let's see. In all of this, President Donald John Trump gravely endangered the separation of powers within the government and its institutions. He threatened the integrity of the democratic system by condoning the undermining of the judicial independence of the federal judiciary, violating the Due Process Clause in the Fifth Amendment. Well, at least he got that right. So there are two due process clauses. There's one in the Fifth Amendment and there's one in the 14th Amendment. The 14th Amendment applies to the states. The Fifth Amendment one applies to the federal government. So at least he got that right. Ignoring the separation of powers, condoning the flouting of orders of the United States federal courts, all of which have caused the devolution of democracy within the United States of America into authoritarianism. With him, how many times did 10 times. 10 times he uses that word. You know what? I have a question for Grok. How many articles of impeachment were filed against George W. Bush? Oh. Oh, actually, there are some. So, Congressman Dennis Kucinich, along with co-sponsor Robert Wexler, filed 35 articles of impeachment against George W. Bush on June 10th, 2008. And it all went down to one article of impeachment on July 4th, 2008. Okay, so same question, but for Obama. So, Breezy, the problem is we're Americans. We don't commit war crimes. Let's see. No formal article of impeachment was ever filed against Barack Obama. How about Joe Biden? I think there was one filed against Joe Biden. Didn't that happen? Marjorie Taylor Greene, Bob Gibbs, Lauren Boebert, Greg Stube, Taylor Greene, Lauren Boebert, Corey Mills. So that's 1, 2, 3, 4, 5, 6, 7. 7 times Republicans filed articles of impeachment against Joe Biden. How about Clinton? And well, Clinton would have just had the 1 or 2. So this is the thing. Clearly, there's obviously an issue. Not only do we have members of Congress that just don't give a shit anymore. All they want are to hang on.
Objection. Objection. Objection.
What a great show. If you haven't watched that yet, you really should. It's called The Practice. 8 seasons, I think. It's really good. Again, let's refresh Twitter to see if we've got any update on Ninth Circuit. Because they could go, that decision could be out in another hour, even 2 hours. Still nothing. Oh, that is the actual video. Night Court is really good. Night Court takes kind of a comedic approach to the court system, which is, honestly, is probably a good thing. And my understanding is that the remake they made claiming or making the judge's daughter is actually pretty good. and it's got a bunch of the same characters in it. No decision yet. This is annoying. They're probably waiting to see what Judge Breyer is going to say. Anyone got any questions? It's only been an hour and a half. I'm game for another half hour at least. Anyone got any topics, questions, consideration? Ooh, bunch of viewers dropped off. Someone must have gone live. Did y'all see? Let me see if I can find it. Oh God, Risky, that took me a second. Now I'm lurking and grabbing booty. I thought you were telling us something. Objection. Okay, how about this? Let's talk about face coverings. Okay, so we've seen a lot of ICE agents, a lot of FBI agents, a lot of basically any sort of federal law enforcement have been covering their face with face masks. And a member of, I think it was the California Senate, Senator Police. Yes. An act to add section 185.5 to the penal code relating to law enforcement. Existing law makes it a misdemeanor to wear a mask, false whiskers, or any personal disguise as specified with the purpose of evading or escaping discovery, recognition, or identification while committing a public offense. This bill would make it a misdemeanor for a law enforcement officer to wear any mask or personal disguise while interacting with the public in the performance of their duties, except as specified. The bill would define law enforcement officers in the okay. Well, I'm sure we know what that would be. Let's see. So, okay, here's an issue. This bill would impose this bill would additionally state the intent of the legislature to enact legislation to ensure that special weapons and tactics team officers, SWAT, can utilize gear necessary to protect their faces from physical harm while they perform their duties, and to enact legislation to require local, state, and federal law enforcement officers to include their name or badge number on their uniforms. This bill would declare its provisions to be severable. The California Constitution requires the state to reimburse local agencies and school districts for certain costs mandated by the state. So this is just another omnibus bill. Let's see. Well, it strikes a whole bunch of shit. Yeah, a law enforcement officer shall not wear any mask or personal disguise while interacting with the public in the performance of their duties, except for medical grade masks that are surgical or N95 respirators designed to prevent the transmission of airborne diseases, and masks designed to protect against exposure to smoke during a state of emergency related to wildfires. So yeah, and Clyde, this is going to be a federal challenge. This is going to be a federalism thing. It's going to be very interesting to see how the courts rule on this. Because look, no, the state law cannot place limits on federal agents. They are above them. But when you're going into a hostile place, you want to try to do everything you can to keep the locals happy. This is going to be very interesting. I actually have this checked off to track. I don't expect this gains much traction in the next couple of weeks. I think once ICE kind of finishes this ramp up, I think they're because I think ICE and DHS and FBI. I think they're gonna keep going hard in California, and then middle of July, I think they probably stop as long as there's been enough time between incidences, let's call them. I think they're probably going to stop and move on to another city. We saw the other day that Trump basically ordered the ramp up of ICE, not jobs, what are they called? Operations in the larger cities here in the United States. So eventually they're going to need to move on from LA, even though LA is definitely ground zero for all of this. They're going to need to move on. They're going to need to go to Chicago. I think they'll get a lot of people out of Chicago. I mean, we're talking, and this is a case where I think they'll actually get a lot of help from the locals in Chicago, because a lot of the people that live in Chicago are sick and tired of losing everything to immigrants. They think about when Trump was up there in Chicago, and so many people came out, not necessarily to support him, but to talk about the fact that illegal immigration in this country was making Chicago poorer. It was hurting the black people in Chicago. It was doing a lot of bad to actual Americans in that city. Well, and that's the point, Hokies. What you have here is you have an instance where we saw this I think 2 weeks ago, where the deputy director of ICE came on TV and basically said, no, the reason they're wearing masks is because this asshole has been going around doxing them, and people have been showing up at their homes threatening them. That's why I ordered them to wear masks. And I'll tell you right now, there is no way in hell a judge is going to be able to, because as long as they still provide name, rank, and serial number, as long as they still do that, there's no way a federal judge is going to be able to say, no, you can't wear a mask. There's just no way. That you want to talk about something not reviewable. What they wear is definitely not reviewable. I think that's about it, guys. Again, unless anyone's got any questions. Man, I was really hoping, and see, I'm almost tempted to just keep going, because last week, literally about 20 minutes after I shut it all down, the district court ruled. Come on, give me some news. Let's see if Pacer has anything. I don't think I'm going to actually be able to use it, though. Log in. Yeah, I need to activate that account. I have so Pacer is the public access to court electronic records. I have an account for it, but I haven't used it in 5, 6, 7 years, so it's inactive. So I can't actually look up documents. Trump. Whole lot of lawsuits. Oh, I'll tell you. Okay, we're gonna end on this. Who saw this? Let me. I gotta go through Twitter real quick. What's that bitch's name that sued him? Carol. E. Jean Carroll. Thank you, Corn Boy. Okay, who saw this? All right, I don't want to get to a like partisan tweet, so give me 1 second. Ooh, okay, real quick. I do. Okay, everyone remember how Jay tells everyone this is not financial advice? Well, this is not financial advice, okay? But this is something to watch, okay? So the Federal Reserve Chair, Jerome Powell, said that in the meantime, we have to keep rates high to get inflation down, yada. Maybe and then he also kind of threw shade at Trump about the tariffs. But in this entire interview, what they don't talk about is the fact that he did mention that they might look into a lowering of the rate in the second half of this year, likely targeting September, October. 100%. And this is the thing. Trump doesn't want a 0.5 point rate reduction. He wants like 2.5 points. So right now the rate is basically 6.5, plus or minus a little bit. But the rate's basically 6.5. Now, if you go new construction, some of these builders are throwing like really great incentives. They're not only giving money for, which this is very common, they'll give money for closing costs, but then some of them will also buy down your rate for you. So you'll start, especially if you use their lender, you'll start with an automatic, like instead of 6.5, you'll start with like 5.5. And then you can go buy down that 5.5. So this, if Trump gets his way, and this is my expectation, that we're going to see right around the start of school, maybe Labor Day, Trump's going to start going after Jerome Powell and the rest of the board. And these are people Trump can fire, and he will fire them. If he fires these people and appoints new members, guys, you will see everyone be able to buy a house. That's how you do it. Force them to lower the rate by a large amount. Let new time homeowners get in there. Now, the big issue with that, is you do create a rise of the cost of the price of the house, because if you have more people wanting to buy, they're going to raise their prices so they can make more money, et cetera, et cetera, et cetera. So you got to find that magic number. And in my opinion, the magic number is going to be 5%. A 5% interest rate is still pretty dang good, but it allows you to buy down if you want to. And I mean, we're talking about, $2,000 can buy down to 4.5%, depending on your lender. So I think what we see is in the second half of this year, we see a point reduction to about 5.5%. And then next year, we're going to see, and this is going to be part of Trump's and the Republicans' campaign, is we're going to see a giant reduction in probably 2 or 3 drops in the rate. And it could go down, it could end up being in the 3s. And that's going to help a lot of people, because what a lot of people are going to end up doing is basically anyone that bought a house in the last 4 years, they're going to refinance their loan, which is actually going to push their loan another 4 or 5 years maybe. But then it's also going to allow them, it's going to free up probably about $400 to $500 a month for them. So this is, I think, the plan. Trump is hoping that he can get rid of a bunch of debt, refinance a lot of the loans that the government has, and then force the Fed to lower their rates so that we can refinance a bunch of our loans, which then allow us to free up hundreds of dollars, and in some cases, for some people, maybe even thousands of dollars on their mortgages a month. Think about what So everyone here has a budget. We all kind of have an idea of how much money we can spend a month. Imagine being able to spend another $300 to $500 a month. Now, for me, right now, I'd probably put about $300. Let's say it freed up $500. Okay, let's say my rent went from, let's call it $1,500 to $1,000. If I freed up that $500, I could, I'd probably put $300 of it in savings. But that $200 multiplied across 200 million people across the United States, guys, that would be incredible. What's up, Drunk 3PO over on Rumble? How you doing, man? I didn't get a phone call from you today about meeting up over in Florence. Just saying. Okay. Star Wars dog is calling me. Okay. What was I going to look up when I saw this? Oh, yes. Okay. So this is the last thing we're going to look at. But I don't want a crazy looking video of her. Okay. So I don't really care what the tweet said. But look at this. Okay, my commentary is not on the tweet. Okay, I don't give a shit what she said. I don't care what her book says. I don't care anything about what this woman says. This thing that annoys me the most about the left. I greatly hang on one second. I am greatly annoyed by just about everything that the liberals, Democrats, leftists, libertarians, any of them. I'm greatly annoyed by anything they do. But the thing that pissed me off the most in the last 4 years, the state of New York passed a law that said, hey, there's a statute of limitations to bring a lawsuit on stuff, but we're going to pass a law that removes that statute of limitations so that victims of sexual assault can bring a lawsuit and against their attackers. And that was done for one thing, so that this woman could sue Donald Trump and take him to court and embarrass him during the election cycle. That's the only reason it was done. And it is the very definition of weaponizing the law. And it is abhorrent to me. I don't like a lot of things the Democrats do, but there are processes and systems in place to fight those things. From peaceful protests that are protected by your First Amendment rights, to taking them to court. What isn't part of that process is changing the law so that you can attack somebody. And that's what happened here. My other question is, who thought it was a good idea to have, let's see if I can, to have this be what she looked like in court and not this? I can't believe that they thought this, whoever does PR or whatever for that entire situation is dumb as hell. It should absolutely be punished harshly. Passing a law, amending laws so that you can go after political opponents. Blows my mind. Guys, that's going to be it. Thank y'all so much. We dipped down here near the end, but I greatly appreciate everyone being here. I hope y'all have a great time. Hope y'all had a great time. Very true. They are different. I don't know if we'll be doing a live show next week. This was supposed to be every other week. We've now done it 3 weeks in a row. I really do enjoy doing this, but part of the reason that it was supposed to be every other week was so that I could take time with King's advisors to do stuff and spend some time, not necessarily learning the law, but kind of reminding myself what certain things mean. Because, you know, when you go through law school, you learn a whole lot of stuff. And then you go take the bar and you learn even more stuff in a very quick period. And then when you start practicing, you kind of throw everything you don't need away. And that's kind of what I've done the last 4 years. So there's a lot of stuff that I'm trying to kind of relearn or remember at least. And the purpose of doing this every other week was to allow myself that time so that I didn't necessarily feel pressured to have the answer every single time. But I mean, we'll see. You know, maybe I'll just get a primer and, you know, read through it. I'm sure Mark Reality has some ideas. Guys, thank y'all so much again. I would throw my heart out to you, but I don't want that to get clipped. So I'm just gonna say peace out. I'll see y'all next time. And hour and a half from now, we'll be playing some Night Rain with X-Wing and Fear the Beardo. So until then, guys,